All right, you are live.
All right, first item of business is approval of the minutes for the January 24th, 2022 meeting. We get a motion? We have a motion, we have a second. All right, we have a motion and a second. All those in favor say aye.
Aye.
Aye. Opposed? All right. Item number 0578-21, communication sponsored by Alder Cove for training from the City Attorney's Office on process and procedures of the Public Safety and Licensing Committee. And I'm going to apologize. I should have did this. We should have did this at the beginning of April. And later on in the meeting, I'm going to make a motion that we add this at every meeting before the new committee is set. The first meeting is for a training session because I think it'll help us immensely. So moving on, we're going to turn this over to Attorney Arnn.
Thank you so much, Alder Cole. Good evening, members of the committee. Thanks for being here today. I just wanted to start off by saying that some alders to this committee are newer. There are some newer members to this committee. There are some that weren't here in 2018 where there was a huge amount of changes made to the alcohol licensing regulations. And even if you were here during that time, it might be difficult to remember because it was 4 years ago. So with the blessing of Alder Cole, we thought it might be helpful at this point to review some of the issues that we as the committee, or you as the committee, faced back in 2018 and before that, some changes that were made going forward, and hopefully we can learn from those changes here. So please keep in mind, as Alder Cole said, this is not a general training. We're saving that for April. So this is a very narrow focus of why we made those changes in 2018 and hopefully what we have to learn from it. So obviously this is here for your benefit. If you have any questions, feel free to stop me at any point. All right. So if you give me a second here, I will share my screen with you. I do have a PowerPoint, so I'll pull that up. Can everyone see the screen, my screen on their phone?
Yes.
Okay, perfect. Do you see me as well or just the screen?
Yes, I see you in the bottom, yes.
Okay, all right. I'm going to start the PowerPoint presentation. There we go. All right, so I'll go ahead and start with a brief history here.
Mike Ellis, 173, please. Mike Ellis, 173.
Sorry about that. I'm not sure what that was. So back in 2018, the committee dealt with a variety of issues that you may or may not have heard about. In some, there was a lack of uniformity when it came to decisions from the committee and the council because there was a lack of guidelines, both in the ordinance and policy-wise. It was very problematic and created a lot of liability on behalf of the city. So due to those many issues, there was a collaborative effort with various city staff members as well as other departments. I also met personally with members of the Tavern League and quite a few aldermen. We came up with comprehensive changes to both Chapter 6 and then created some policy guidelines and new processes going forward. So the point of this training today is really to review some of those changes for your benefit. I would note that after these changes were brought to the Common Council, it was discussed at length and ultimately approved by the committee and the council back in May of 2018, and it has been revised a few times. So sorry about that, I forgot about my slide. So there were major changes in 3 broad categories. The first being the use of discretion in granting of license, specifically alcohol license. The second one is dealing with false statements on license applications. And then the third had to do with the disciplinary process. So I will go ahead and start and take each one separately. With respect to the granting of license, in 2018, we really didn't have any factors specified in the ordinance as to what the committee could or should consider when determining whether to grant a license. So as a result, the committee wasn't always sure where to start, what sort of questions to ask. And likewise, the applicant did not know what to expect when they came to these type of meetings. There was also the problem of incomplete applications or information. These applications really were not reviewed thoroughly before they came to the committee. So a lot of issues that arose during these meetings. And during the public safety and licensing meetings, the relevant departments who may have material information were not present. They weren't able to add any information. Things were not disclosed. There was really no way to follow up or investigate some of these issues. So the committee was forced really essentially to make a decision at these hearings that were public when everyone was present with incomplete information. There's also the problem of unclear expectations. A lot of newer applicants particularly would often say they weren't aware that what their responsibilities were. They weren't aware of what the law was or the regulations. They would come up and say this frequently to the committee members who really wouldn't know what to do at that point, because if the person says they didn't know and we never communicated any expectations to them, it was difficult then to deal or address the problem. And as I stated, there's really a lack of participation from any of the city departments. For example, the police department or the health department, a lot of times these applicants do have very specific experience that involve lengthy issues from other departments, and these issues really never came to light at these committee hearings. It was really a reactive rather than proactive approach. The idea is really give a license to everyone, and then when the issues come up later on, we deal with the issues, which, as you can imagine, was a big problem. There was really an all or nothing approach to it. There were a lot of license applicants who had red flags on their applications, but because the committee wanted to give them a chance, they would either have to say, yes, you can have the license, we'll just give it to you and see what happens, or no, you can't have a license. There was really no in between. And I'll talk about that later on as to some of those changes that we made where there is some wiggle room so that it's not an all or nothing approach. And because of all of this, there was really, the end result was a lack of uniformity. There were inconsistent decisions on each applicant, and it really resulted in a lot of nuisance properties that we then had to expend more resources to deal with in the end. So some of the changes that we made included the creation of, as you know, the Good Neighbors meeting. So with the Good Neighbors meeting, it was, and before we jump into that, let me just point out, due to all of those issues, I think the committee realized that it was much easier to grant a license than to take away a license. Remember that when you're granting a license, you as a committee has a lot of discretion weighing whether or not they should get a license, and you have a lot of authority to do that. However, once you grant a license, it is a property right in the state of Wisconsin. It can't be taken away without full due process rights. So it's very important that you put the scrutiny up front so that you don't deal with this problem later on. So with that in mind, these changes I stated included the Good Neighbors meeting. This is a meeting that involved all relevant departments. There was always a lot of issues involving the applicants who would say, well, I didn't know this, or this department stated this, or that department told me this. So the information was not uniform. It wasn't comprehensive. So the Good Neighbors meeting is really a good place for all the departments to be there so that we're giving the applicant the same information so that they are not confused. They also have a good contact person to go to from each department when they do have questions. We spend a lot of time really setting expectations at these Good Neighbor meetings to tell them what the city expects, to tell them what their responsibilities are, both legal and moral obligations when it comes to having an alcohol license within the city. That way everyone's on the same page. So it also allowed for a lot more candid discussions. If there is an issue to be dealt with, if it is a location, for example, that has a history of nuisance issues, Meeting with them at a Good Neighbors meeting with all the departments involved, especially the police department, is a much better way to address some of these issues than to go to a committee meeting with the alders who don't always have all of the relevant information that we need to deal with these issues. So as I stated, the discussions are a lot more candid that way. And remember too, that with the Good Neighbors meeting, it's not just required at the beginning. You can also use that as a tool when it does become a nuisance property down the road. So if you're calling an applicant in and it is an issue that might be better discussed in a more candid meeting with all the departments involved, especially the police department, then you as the committee has the authority to refer that licensee to a Good Neighbors meeting so that they can deal with those issues rather than just saying, okay, you said it's not going to happen again, so we'll just let it go. Sometimes that doesn't work out well. So those are some of the things that you can do with the Good Neighbors meeting. Our focus at the Good Neighbors meeting is really to help them abate the problem. It's to help them be a good neighbor. The department representatives who are at these meetings are not in charge of them obtaining their license or keeping their license. So we can be a lot more helpful in terms of how to address the issue without making the person feel as if they're put on the spotlight or that they're being attacked. So those are some things that we can do at the Good Neighbors meeting. We also made some general ordinance changes. For example, we listed the criteria in the ordinance under chapter 6-23 as to what the committee can and can't consider when granting a license. So if you haven't taken a look at that, it might be helpful to look at. But it includes, for example, the appropriateness of the location and premises to be licensed. It includes the applicant's prior experience and lack thereof in operating a business. I know there's been a lot of discussion about whether you can use the applicant's experience when deciding whether or not to grant a license. But in all honesty, that really is the best indicator of whether they are going to operate a nuisance property. And by ordinance, you are allowed as the committee to consider that as a factor. So the other thing I wanted to point out is one of the overarching factors that you can consider is any factors that reasonably relate to public health, safety, and welfare. So that's kind of a good guide for you. Your job is really to make sure that it doesn't become a nuisance property. So any information that you have that relates to that can be considered by the committee. We also added that licensees are responsible for the acts of their employees. If that wasn't clear before, it's clear now. And then the nuisance and disorderly premises. So licensees are responsible for their premises becoming a disorderly premise or a nuisance premise. So you can hold them accountable. They can't just say, you know, at 2 o'clock or 2:30, I'm going to lock my door, push everyone out. They're not my problem, because by ordinance, it is their problem. So you can certainly hold them accountable for that. The other change that was made to the ordinance is the adding conditions as part of the license. And this does not get used often enough by the committee. I talked about an all or nothing approach where, you know, the committee is faced with an applicant that does have some red flags, but at the same time, you do want to give them a chance. Well, adding conditions to a license is a really good way of doing that. For example, if you see a premise that might have issues with noise control, one of the conditions that you can put on there, for example, is, you know, approve the license with the condition that any outdoor amplified sounds is prohibited. Or if they're applying as a restaurant, but they're looking more like a bar or a nightclub, you can place the condition that food must be served anytime the premises is open, so that they are in fact operating as a restaurant rather than a bar or a nightclub. So there's a variety of conditions. So long as they are reasonable, the committee can place these conditions as part of the license. And I did speak with the city clerk's office. They do intend to print any of these conditions that are placed on the license onto the license itself, so that when an officer does enter the premise, they can see exactly what the conditions are. And the other condition that they can put on there too is the limited hours. So for example, if you are approving a license that has on their application that they are closing at 1 o'clock every night of the week, and that's part of their application, and they've agreed to it, and you are approving it with those conditions, the motion should be made to approve with those conditions so that they're placed on the license itself, so that we can enforce those or later on. Because enforcement sometimes can be an issue if we don't know what the conditions are. So that's one tool that the committee can use. The other requirement that was placed into the ordinance is that the licensees or the applicants be required to abide by the business plan as approved. So the application that they can submit to the committee members that states they're going to operate a low-key bar with no live music, that are open specific hours, that are serving food. They do have to abide by that. And if they don't abide by that, let's say they give you a business plan that talks about that, and they end up inviting or operating a nightclub, that's not what the committee approved. We can certainly enforce that later on because they're not abiding by the business plan. So just make sure that when you are approving, you're approving whatever business plan has been submitted to you. You are not approving what the applicant states that they will do. So if they just state at the meeting, well, I plan on closing at 10 o'clock every night, but their application states it's 2 a.m., they are not required to abide by that unless you make that a part of the condition. So I get that question often. So it's just really important that whatever in their application is what you are approving, unless you specifically approve a condition as part of that approval. All right. Let's see here. A conditional grant of a license. We don't run into this problem too much, but just keep in mind that for premises that are not yet open, so for example, premises that are under construction or renovation, you do have to, when you approve, you should be granting a conditional grant of a license. And what that does is it requires the business to operate within 6 months. As you know, the city and every municipality in the state of Wisconsin has a quota for Class B licenses. We only have so many. So when you do grant one of these licenses, it has to be open within 6 months. If the person is not operating within 6 months of Common Council approval, then they do have to give the license back to the city unless they have good cause and you grant them an extension. But the reason we do that is because if they're not using a Class B license, the city should be taking it back and granting it to someone else who is ready to operate a business. But when you do a conditional grant of the license, we don't have to go through a due process procedure to revoke the license. It's a conditional grant condition upon them using the license within a 6-month period. So when they don't do that, it automatically reverts back to the city clerk's office. So that's why it's important that when you do have a business that's not open, that you do approve using that language there. And lastly, I created the public safety and licensing manual, and you'll find in there, I'm sure all of you have it electronically, but you also have a hard copy at the city clerk's office if you ever wanted to pick it up. But it does have a uniform speech for each type of license that comes regularly before you, so that the applicants know what is expected, what they're being asked. There are a list of questions on there that might be helpful the committee may want to ask, and it does require the swearing in of applicants for alcohol licensing. So if you don't have any questions specific to the granting of license, I will move on to dealing with false statements. Yes.
Yes, I have a question.
Yes, Alder Peterson.
Conditions as being part of the license.
Yes.
When somebody comes in and states that they plan on closing at 1 or 2 or whatever, and for whatever reason, we're uneasy with that, can we as a licensing committee state we're not comfortable with that particular location or this particular operator? As a committee, can we say we're only comfortable with you staying open till midnight?
So you the law is a little bit tricky because technically the municipality cannot unilaterally force a Class B license to close early. However, if it is part of their application and they agree to it, then you can. So in those instances where you are more comfortable with the person closing at 1 o'clock rather than 2 or 2:30, then what the committee should do is state, these are the hours that we are comfortable with. We're going to defer the application. Why don't you amend the application if you want to do that? Come back to us with an amended application, and then we'll consider it at that point. That would probably be the most appropriate way to handle that situation, because then it's in writing, it's part of their application packet. Now, if they choose to not do that, that's fine. And the committee has concerns with respect to the health, safety, and welfare of the public, with respect to the hours that are listed on the application, then you can certainly deny based on that.
Okay, thank you very much.
Any other questions from anyone else?
I have a few questions.
Of course.
Thank you. To go to those conditions, is there a limit on conditions and the type of conditions that we are allowed to ask for an applicant?
Yes, so the law states that the conditions must be reasonable. That's all it states. So if there is a discussion with respect to what the issues are, what the problem is, and the solution does seem to fix that problem or that issue, then I would say that it's reasonable. But it's hard to answer hypothetical because I don't have a list of all the conditions that you may want to place. But the bottom line is, so long as it's reasonable, then you can do that.
Okay, thank you. And if the chair doesn't mind, I have two other questions. Okay.
Go ahead.
Thank you so much. You talked about the Good Neighbors meeting, and I was just familiar with that coming along with the new applications that come before us. But the way you referenced it is that we can use it as a tool to use if we are dealing with a licensed applicant and some things are occurring or we're seeing some things. So that is something we can use at any point. And if that is true, do we have to have that be a motion on our committee that we are requesting a Good Neighbors meeting for a certain licensed applicant?
That is true. You can use it for that. When we created the Good Neighbors meeting, that was the purpose. It was to deal with nuisance property, both upfront and as they become a nuisance property. And the answer to your second question is there's no formal motion needed. If the committee agrees, you can direct me to meet with the members or the licensee. I will gather the other departments and we'll meet with them. However, when you are calling in a licensee as part of a formal expression of concern, I recommend making a formal motion just so that we can have that be part of the record, that that's the action that was taken as a result of them being called in.
Okay, thank you for that. So just for clarity, so if our committee happened to have a conversation in regards to wanting a Good Neighbors meeting, and it's just something that we're talking about, then you would take note. I'm just a little unclear. Why wouldn't that be a motion just for record's sake? I'm sure a motion probably wouldn't hurt. I'm just not sure how to guide you without one.
Sure.
If we're just having a casual
Sure.
conversation.
Well, I say that a motion is not technically needed because we have had Good Neighbors meetings proactively as with other departments to deal with nuisance issues, even without the committee's involvement. So a lot of times, if there is a nuisance property and the problem keeps happening again and again and again, and the violations keep mounting, rather than issuing a summons and complaint, which the city attorney's office can do on its own, we sometimes have set up a Good Neighbors meeting, pull in the police department, the health department, the building department, whatever department is relevant, sit down and have a conversation with the licensee. So we don't necessarily need the committee's direction to do that. We have done that in the past, particularly in periods where the committee has not met for a long time. For example, during a long Christmas break, if there's a lot of issues, we use that technique to kind of deal with the problem rather than letting it become a bigger issue before it gets to the committee.
Are those records then, the Good Neighbors meetings, proceedings and stuff offered up at this committee, or at this committee, I'm sorry, for review if we needed it?
As a rule, I usually write the report and submit that to the committee after that has occurred.
Okay, thank you. And I have one final, but thank you. You talked about the business plan, and when a business deviates off of what we have agreed to, what then is our, how would we enforce that? How do we enforce if they deviate off of that?
Sure. So there are two ways to enforce it. The first one is really through the police department, because it is listed as a requirement in the ordinance. The police department can certainly cite for that. As a practical matter, it's difficult for them to do that because they're police officers. They're trained to enforce usually more traffic, criminal related offenses. They don't deal a lot with licensing issues, except with the exception of Sergeant Ortiz, of course. So they're not too familiar with that, but there have been times when there is a violation, and when I do receive notice of it, if it is important, I will ask the police department to go out there to cite the licensee so that they are cited with that, enforce it that way. The other method of enforcement is, and I have done this, sending cease and desist letters, or sending them a warning letter essentially from the city attorney's office to let them know that this is a violation. But really the best method for dealing with that is really for the committee to call in the licensee to state, hey, this is what we approved your license for. You're not doing it. And then take action that way through a formal expression of concern.
Thank you so much.
You're welcome. All right, so unless we have any more questions about that issue, I will move on to dealing with false statements. So the problem of false statements. The former application back in 2018 had some wording on it that was a little bit confusing, and it was and has been amended quite a few times. But that, as a result of the way the word was questioned with respect to the person's arrest and conviction record, it created a lot of issues because the person would check no, that they had not had any convictions. They would come before the committee. We would get the background check back, and lo and behold, there's a conviction or an arrest record. So that was always part of the problem. The person would come in, and the response almost every time uniformly is, I forgot about the arrest or the conviction, or I didn't know is the other response. And because there was a lack of policy guidelines, there was no clear rule on when a person was disqualified. It really resulted in inconsistent decisions by the committee members as to when to approve and to grant a license, and with respect to what offenses qualified or disqualified the person. And then you have this problem with withdrawing of applications. It was often suggested to the applicants at these meetings, once the background check came back, that they should just withdraw their application, come back in a year, or withdraw their application, uncheck the box essentially, and then resubmit the application to the committee members. And as you can imagine, that creates a little bit of a problem, and I'll go into that a little bit more here. So the changes that we made, the first change was really rewording the question. The application now states, have you ever been convicted of any offenses? And then in parentheses, it states, you do not have to list minor traffic offenses. So that is pretty clear. It doesn't ask about the person's conviction. So it doesn't say, were you convicted of an offense? It doesn't say, were you convicted of any misdemeanors or felonies? It just states, have you ever been convicted of any offenses? So that question should make it very clear to the applicant that there's no time frame involved. We're not asking about the last 5 years or 2 years or 10 years. We're asking ever. We're not asking about felonies or misdemeanors or municipal citations. We're asking, have you ever been convicted of an offense? So when the person goes before the committee now and they say, I didn't know, that might be a little hard to believe because the question is so clear. And we made that change specifically because so many people were saying, I didn't know what the question was asking. So that really should not be an issue anymore with the way that it's worded now. We also came up with policy guidelines that you have in your public safety and licensing manual. And what that does really is it takes out all of the offenses that would be considered relevant to owning an alcohol license. And it states which offenses would disqualify the person and what time frame that applies to. So using those policy guidelines, the police report then fills out the cover letter that you see as part of the application in the agenda that states the person is disqualified due to guidelines number 1, 2, 3, 4, or 5. So that's where they get it from. They're using those policy guidelines that the committee approved. Those are offenses that the committee considered to be relevant and important enough to disqualify the person within those specific timeframes. And the other thing that was contained in the policy guidelines as well is good cause, because there were so many people stating, I forgot, I didn't know I had to list it. The committee decided to put in language in there that required the good cause as to why the person neglected to disclose a specific conviction. And it specifically states that good cause does not mean I forgot. So really, the committee made that decision then to say, enough, we've had enough of this. We don't want to hear I forgot anymore, or I don't know why I didn't list it in there. That's not good enough. So there has to be good cause. I will say it's very important, because the committee approved those changes, that you follow those guidelines, because when you start deviating from those guidelines and you make exceptions here and there, it really becomes inconsistent. Then you're really just picking and choosing who you're approving. For some people, it's okay to not disclose, and for others, it's not. So it's very, very inconsistent if it's not followed. So I'll say more about that a little bit here, but I'll move on to the other ordinance change. So the other ordinance change that was made in the withdrawing of applications. So when a person comes before the committee and they have, for example, a background check, and it does come back and they did check that they did not have any convictions or any pending convictions, the person, actually any person, is prohibited from withdrawing the application once the committee meets on this item. And the reason we do that is because if the person comes before the committee and they were allowed to withdraw their application and resubmit the same application, just unchecking the box, what that does is it deprives the committee members of any grounds to deny the application. So the ordinance doesn't allow you to do that anymore. It doesn't allow the applicant to withdraw the application. Okay, and that's the reason we do that. Certainly you can, I know this was discussed at length at the last meeting as to whether or not the applicant can withdraw their application and resubmit it. But really that ordinance change was placed in there to avoid this very specific situation. Because if you start granting this and you start allowing people to do that, what's going to happen every time is other applicants will start doing that. And then the committee will never have any grounds to deny an application based on a false statement. And if you allow this applicant to do that, but you deny the other applicants, future applicants, then it's really inconsistent and creates a liability on behalf of the city. So it does certainly become an issue. All right, before I move on to the disciplinary process, do we have any questions at all on that false statement section?
Yes, I do. Question as far as granting bartender's license versus liquor license. We've obviously been much more lenient on individuals where we are just granting a bartender's license to, a license to serve. How do you view that? I mean, there's obviously quite a difference in responsibility to having a liquor license versus serving alcohol.
Sure.
Should we be more stringent on individuals? Because we get a number of people applying for for liquor licenses that for whatever reason, don't put down something that's honest or something that disqualifies them. How do you rate or rank how we handle the two differently? I mean, should we be handling them differently, or should we be handling them alike?
Well, let me start by saying that the Wisconsin statutes that govern arrest and conviction records treat both of those type of license the same way. So it just states that a person cannot have an offense that substantially relates to the business of selling alcohol. And when you pass the policy guidelines, those treat those two types of license the same way as well. However, I understand the need to treat those two differently just because of the responsibilities involved in each of those type of license. So the committee can certainly do that, but if you do that, then I recommend that you change the policy guidelines so that you are still following your own policy guidelines that you set, because currently those policy guidelines apply equally to both those types of licenses.
Right, I'm not sure if the committee chair should get that going or what, but I do think they should be handled differently anyway. Like I said, somebody working at a convenience store selling alcohol by the bottle or by the cans is totally different than somebody that operates an establishment. So I'm not sure how to go about that, but I think it should be handled separately, because I know we have handled it separately as far as how we choose to either give the license or not give the license, approve or deny.
And for the most part, just interjecting here, just for the most part, we should have been following these guidelines a long time ago. And I'm just as liable as everyone else for that. Let's give a person a break. But I've been going on for how many years, and the people keep coming in and going on and saying, oh, I forgot. I mean, I guess we have to start saying no, so people moving forward are not going to say, lie on these applications. Otherwise, we're going to keep having these come up to us. And so that's the reason I say that they should be treated the same at this time, but we can have a discussion on that, Alder Peterson.
All right, thank you.
I would like to chime into that conversation. I think Alder Peterson brings up a very fine point for sure. And there has been a lot of variation between the two. But I can understand why those policy guidelines are in place just for consistency. We've been talking about what happens or what could happen with this deviation, and then there can be some inconsistency. I'm not sure what it would look like with us changing it to kind of match what we're doing, because I'm not even sure if we're so consistent, because our conversation and even the line of questioning and what we're asking has not been the same for those who have deviated away. I mean, some of us kind of stick to that same narrative, but there is variations in that with the various bartender license that comes before us, or that applicant. So, just keeping that in mind, I can understand why this got put into place. And you're right, we either stick to this or we make an amendment, but there's just so much gray area. So, okay, thank you.
Okay, so if there are no other questions, if you ever decide that you do want to have a more thorough discussion on that, I recommend putting that on the agenda as a separate item so that you can have a full discussion. Okay, so as far as the disciplinary process was concerned, there were a lot of issues associated with how the committee chose to suspend or revoke a license, or how to put them through the process. And it started with a lack of criteria for due process. So the way it worked before was that the committee would get a hold of information, sometimes from the licensed premise report, sometimes from the bar down the road, sometimes from a citizen complainant, sometimes from other alders. They would call the person in, the licensee in. They would either vote to take their license away, to go immediately to due process, or they would vote to do nothing. If they voted to go immediately to due process, the committee would then set up a hearing date. That same committee would then discuss the allegations and decide whether to revoke or suspend a license. As you can imagine, that was very problematic. It was the same person who filed the complaint or raised the issue who would then ultimately decide whether to suspend or revoke a license. So that was very problematic. There was really no criteria for calling the person in or sending them to due process. There was also a lack of uniformity. It just really depended on the person's day, what committee members wanted to hear the issue. And it wasn't based on specific evidence or violations at all. It was a very unpredictable process. The committee members didn't know what to expect sometimes. So certainly the licensees and applicants did not know what to expect as to when they would be called in or what would happen when they were called in. It was often very abrupt and without warning. We didn't have any sort of system set up so that there was a warning system or a 3-strike system or a point system or anything like that. So that made it very chaotic for a lot of the licensees and applicants. There was also very little room for problem solving in the sense that the person would get called in front of the committee members at one of these hearings. It was obviously a public hearing. There would be discussion, but there wasn't a lot of room to come up with solutions from, for example, the police department, who might have helpful suggestions when it comes to nuisance properties. So there's really no room to do that back in 2018. And as I stated, there was really a lack of participation from other city departments, which can be very helpful because they are familiar with these licensees from other perspectives, from different license processes. So some of the issues, two major changes really that we made to the disciplinary process. The first one was really to put in place a system that allowed for the person to be notified or to be warned before they got to due process. We started with the proposal of a point system that was discussed at length by the council. It was ultimately voted down. So rather than having a point system, we came up with what you have now, which is called a formal expression of concern, which allows for really a 2 or 3 strike system. And the way it works, as you know, is every time the committee calls an applicant in, it is a formal expression of concern. Whereas before, when the applicant was called in, sometimes it counted against them, sometimes it did not. This way, every time the person is called in, it is a formal expression of concern. Once the person comes in front of the committee, obviously the committee has the option of rescinding the formal expression of concern. I would ask that you use that option very lightly or seldomly. The only time that a formal expression of concern should ever be rescinded is if, one, it was done in error. There was really no violation whatsoever, and this was just a mistake calling the person in. Okay, or 2, there's never any violation. So most of the time when you are calling in an applicant, it's because the person did have a violation, but they are abating it in some way, shape, or form, or they have come up with a solution to fix the problem, which is great, which is what we want. And that's why you have a formal expression of concern, because the first one is really just a warning. But the reason you want to receive and file it, which what it does is it keeps it on the record so that we can count towards the 2 or 3 strike system. And the reason you want to do that is because then you don't forget about it. You may have an issue that comes up once and it doesn't seem like it's a big deal and the committee rescinds it. Well, you see it 2 months down the road and you rescinded the first one, so now we can't do anything with the second one. So really what it does is it's not helpful for the committee to do that because you're treating each of those licensees differently. We created the system so that every time the person is called in, it counts against them. And those are just complaints. Keep in mind that when you call someone in, you're building the system, but when they get to due process, it does not necessarily mean that the person gets their license revoked. That's up to the due process board. And that was really the second creation here. The process is created so that at the committee level, it's really just to filter out complaints. It's to deal with complaints that come in. You are receiving the complaints. Your job then is to really figure out if there's a solution going forward as to how to fix whatever problem it is. And then the second step is to send it to the due process board. It goes automatically there after 2 or 3 strikes. And they are the ones that get to decide what to do with those violations, whether it was a serious enough violation to be suspended or whether it should be revoked. And keep in mind that when it does go to due process, it doesn't necessarily mean either one. It could very well be that when you send it to due process or when it goes to due process, there's not enough evidence or the violations were not proven, or they are getting a 10-day suspension rather than getting their license revoked. So that's the range. The range is anywhere from 10 days to 90 days of suspension or for the license to be revoked. So that was created to take essentially some control away from the committee members so that you don't have the power directly to send the licensees to due process. And the reason we do that is because really the complaints come through the committee members to begin with. So it really should be a different body that hears the evidence from an impartial point of view to determine whether these violations have been proven and whether they should result in a suspension or revocation. So whenever you are calling one of these in, just keep in mind that there is a second step and you should let it naturally progress to the second step rather than rescinding it every step so that it never gets there, because really that's not what this process was created to do.
I have a quick question before you move on.
Of course.
As far as bringing somebody in for letter of concern. Okay, so we're going to be having somebody, say if we call somebody in and between the time from one meeting to the next, something else happens at that establishment. Are we able to talk about that, or is it everything prior to our asking them to come in? So if we have somebody January 1st, we have a meeting, we say, well, we want to bring this bar in, and on January 15th, something else happens. Can that be part of the discussion, or it's just everything prior to January 1st?
Everything can be part of the discussion. So remember, when the committee calls the licensee in, your job is really to figure out how to abate whatever the issue is. So you can bring up whatever the issues are that have occurred up to that point and how to address it. When the due process board takes over, if it ever gets to that point, they are the ones that deal with, if the summons and complaint was filed on that day and another violation occurs, does that count? That's really up to them at that point. But for the committee's purpose, you really can discuss any issues that have come up that are creating the nuisance issues at that point.
Thank you very much.
No, I have a question.
Yes.
Yeah, so one of the things I want to ask is, like, even with the due process and a bar owner is brought in, how far back technically should we be going? Like, what are the rules? Like, sometimes we bring somebody in and then it's like, oh, in 19, I'm just going to use this as an example. So we're in 2022. So it's like going all the way back to 2017, 18, 19. It was a call. How far, is there any guidelines on how far we should be going back, with these calls?
For the committee, no. For the due process board, yes. So again, for the committee's purpose, you can go back as far as you want if it is relevant to your discussion at that time. If it is the same issue happening over and over and over again, or there was a history of the same issues happening over again, 5 years ago, you can still bring that up and say, look, there's a history here, there's a pattern, and we want to deal with the issue and the pattern that we see. So you can certainly do that. Now, when it comes to suspension and due process and revocation, the due process board is required to consider violations within usually the last year. So that's up to them.
All right, thank you.
I do have some questions too. I don't know if this is a relevant time, but it is on this topic here about the disciplinary process. So this is something just a little bit different from when I was on public safety prior. And so I'm trying to just wrap my mind around it here. So maybe just if you could help me out. So when we call an establishment in, and our purpose is really to address the complaint and then look for ways to abate it. And is then one of our tools then that we can use the Good Neighbors meeting? And what other tools do we have beside that? Because I think before we could put up conditions that it was just kind of agreed upon, they would sign it, even though, let's say with the hours changed and things like that, we could do that back then, but I'm not hearing that as part of it now. So what other tools would we have with calling them in and trying to abate some of these problems?
To be frank, Alder Caparian, that really is your only tool. Your only tool is to use the Good Neighbors meeting, because once you do grant a license, that is a property right, and they have that license until you go through the entire due process and you revoke the license. That's why it's so important to put the scrutiny up front, because when they do become an issue, you don't have the authority to unilaterally put conditions on the license anymore. You only have that authority at the beginning. So really, we created the Good Neighbors meeting to deal with some of those issues. But to be frank, once they become a nuisance issue, you either wait until they get 2 strikes within a 6-month period or 3 strikes within a year period to deal with that issue. Obviously, if it's a nuisance premise that is serious, where violations keep occurring again and again and again, my office and I do have the authority to issue the summons and complaint without involving the committee to revoke or suspend their license. And we have done that a few times where, there were repeated violations and they were very serious violations. We did not wait for the committee members. We did issue the summons and complaint. So that's how we deal with the more serious ones. But as far as the committee is concerned, you don't have a lot of tools in the middle, to be honest, once you grant the license.
Thank you.
All right, so as I was saying, these changes, the formal expression of concern, what it does is it takes some unpredictability out of the process. Every person that goes to the Good Neighbors meeting before they get their license knows that there's a 2 or 3 strike system. There's 2 within 6 months or 3 within a 1-year period, and they know that it's automatic. So they're told this, and then when they go to the PSNL meetings, and these things keep getting rescinded and rescinded, it's a little confusing to these applicants because they don't know where they are in the process. They don't know how many strikes they have. They don't know how many more chances they have. And that is very detrimental to the process. As I stated, there's no direct votes for due process, so it doesn't give the committee too much power to deal with it, and that was done on purpose. There's a gradual buildup so that the person knows when they're reaching that limit, and it treats every licensee the same way. The result is automatic, and it's automatic based on the violations. It really does, if you follow it correctly, allow for uniform enforcement of the disciplinary process. And keep in mind too, the last thing I'll mention is with the due process board, the way it works is once the person goes to the due process board and the hearing occurs, once the board makes its decision, it does make that recommendation to the council. So the council, in the end, you all being part of the council, do get a say in that discussion as to whether or not to approve the recommendations of the board. And that's why it's important that you stay out of that process to figure out whether or not there was a violation, because ultimately the Common Council does make the decision as it's basically like a judge making a decision on, whether the person was guilty or not. So it's important when they come to the committee in the first place for these complaints that you don't focus on the violation itself. You don't focus on whether or not it occurred. So the person goes up there and they states, that's not what happened. I want to bring in witnesses. I want to show you videos. And this has happened in the past. That is really not the time or the place to do that. The committee's job really at that point is not to decide whether the violations can be proven. It's really just to hear the complaint, decide how to address the issue going forward, if you can, and then send it to due process, let them figure it out, and then discuss it in the end. All right. So the only other thing I'll mention is, we created all of these changes and to the ordinance, both and to the policy guidelines. And it was done with really good intentions in mind. And it solves a lot of issues that the committee is facing now and then, but it only works if the committee follows its own guidelines and follows the ordinance. So we can create all the guidelines that we want and all the ordinances changes that we want, but if the committee applies it inconsistently, it really doesn't work. So really, that's all I have. Do you have any other questions for me?
No.
Yes.
I guess what I'm gonna ask now, is it appropriate? I want to make a motion. I mean, I want to thank you for this. I think this helps us a lot. But I want to know, moving forward, I'd like to make a motion that we approve this. I mean, that we make a motion that before every committee is seated, their first meeting in April, that the first meeting is a training session. And I'm wondering if that's an appropriate thing to do right now, because I think that's going to help in the long run, at least the people coming onto the committee, knowing coming in, they're going to have a training session. And then sometimes you may have people from the state weighing in on this. Am I correct?
First, yes, it would be an appropriate motion at this time. And second, we can obviously at these future trainings get different authorities to come in if it would be helpful.
So, well, at that point, I'm making this motion to do this, and I'm looking for a second.
Second.
All right, we have a motion and a second. Any kind of questions on this item, on that?
I do just have a discussion
Go
point.
ahead.
Thank you. And I think you covered it, how we could have some any type of authority come in. I think it'd be really helpful, just those who are part of the Good Neighbors meeting. You've referenced that law enforcement is there too. We all are different gears in this process, that I would like to have them as part of that conversation during these trainings too, so we can understand what we need to be mindful of and how it affects them on their end.
I think that's a great idea. Perhaps they can share something at the April meeting. I usually reach out to both the city clerk's office as well as to the police department to see if they wanted to add anything to these type of trainings. So I will do that again in April.
Okay, so I really appreciate this. Is there any other questions from any of the committee members at all?
Yep, I got one more, Mr.
Okay.
Chair. And I don't know if you can help me here, not with this one. So basically, since I've been here for the last probably 2 or 3 years, one thing that I see is a huge problem, and that's people going out buying establishments, buying bars, spending money, investing into places, only to find out that they can't open them, or to find out that something is something that's going to prohibit them from doing it. But at this point, they've already spent $100,000. They've already spent $50,000. So what can be done in that area? Because it seems to be that once a person invest and buy, then they're in now. They didn't put their investment in, and then they come down the road to us, or they come down the procedure to get to us to find out that, yeah, you bought it, but there's some things in the past, or there's something going on that we just don't see you opening up this business. Is there anything that we have to address some of that?
Well, let me start by saying that with respect to the building department or the health department, for example, I know that they often speak with applicants before the person submits permit applications or license applications to walk them through the process so that they know what is expected. So I would recommend to the potential applicants to, first of all, reach out to various departments. Marsha from the health department is very helpful at getting back to people and letting them know what exactly they have to do. Ken Plasky, head of the building department, I know they have a program at the building department where they actually walk through and tell you what you would have to do if you purchased a building. So I know they have that in place. As far as, the liquor license process goes, that's a little bit more difficult. Obviously, I don't know what the committee is going to do until it sees the application. And a lot of times we don't find out about these issues until we review the application, speak with the other departments, do a background check, and kind of investigate what the issues are. So it's really almost impossible to tell the person, hey, you have to do this and then you'll get approved, because obviously there's no guarantees. That's up to the committee and the common council. I can't control that. But I will say that if applicants reach out to me and ask, what are the regulations? What do I have to do? What is required of me? We always answer those phone calls. We answer those phone calls, those emails, and we tell them exactly what they have to do. And we help them as best as they can until they get to that process where they have to go in front of you as the committee and as the council. And that's really all we can do.
Thank you so much.
I want to say, I know people have called me for it's the same thing, Alder Horton. People have called me, well, what do I got to do? And I tell them, you go down to whichever department you start in, you have to go to the city clerks, and going forward, you need to know what you're getting into. And I've stated that a lot of times. I've tried to get it, and I don't even know if we're there yet at the city. I wanted to have an application, so I don't care if I start in the city clerk's office or the health department. There should be a checklist of where you have to go to in order to get this. And I don't know if we're quite there yet, but it's better than it was, like, say, 10, 12 years ago. So Alder Perez.
Thank you, sir. So, Attorney Arn,
Yes.
is it possible to prepare a document that says something to the effect of, in order to qualify for a liquor license, you must comply with all these things, including background checks, before you invest in purchasing a license or a property? Is that something we could demand of them?
Well, I believe the city clerk's office does have a checklist that they provide to applicants. When the person comes in to pick up an application, it states everything that the person has to do. And then obviously, if they have any specific questions about any of those items, they can go to those specific departments. So there is a list in place. And then on the city's website, I believe there is, it's been improved a lot within the last year, but I know you can go on there and click exactly what you need, and it'll list the process or the departments you have to go to. And there's a little bit of a checklist on there as well, depending on what you want to do.
Well, one of the reason I'm concerned is because everything that's coming up lately has to do with a person's background and what they've missed on their applications. And I think there should be like in this document, a stern warning that says, you do not qualify if A, B, C, D, E. However, if you do qualify and you can meet these other things, then you still might not qualify because you have to go before the committee. Just to give them kind of a broader heads up, kind of in sticking with what Alder Horton said, I think that there's some misinformation that needs to be clarified. And I've tried to use the website lately, and it's become more challenging than even it used to be, even though they say it's better. You type in what you get, and then you go some page, and then you link, and the hyperlink doesn't work. And then you go back and you try it another way, and then it brings it to a totally different page. And I think we've just created a mess. Maybe a mess that's a little better than before, but not, it still doesn't, we keep getting this comment that the city makes businesses hard to get established. And people with liquor licenses especially say, hey, I did all this and now I come before the community and tell me no. So I think it's not clear that they need to recognize that in order to even qualify, they need to meet certain standards. And that could be, the previous arrest and all this other stuff. And I think that, could we look at that document and revise it to kind of give it like a heads up warning? Don't even bother if you don't meet these, 5 things, because this will definitely prohibit you from getting a license. And then the other thing that they must comply with before and then put a disclaimer is like, before you even invest in buying this, you must comply with all these things so that you know whether you qualify or not. And you still have the possibility of not qualifying, because you still have to go before the committee. Is that even possible?
Alder Perez, we have that exact document that we give to applicants. It's called the policy guidelines. It states exactly what offenses disqualifies the person, exactly what timeframes count. It states on there that false statements also disqualify them. It states exactly what you're talking about. And that document is given to all applicants from the city clerk's office when they pick up an application. So any applicant who is really thorough should be reading the documents that they are getting from the city clerk's office, and that will tell them that they are disqualified.
Can we put it in big red letters, bold? At
I don't know how much
25?
bigger.
Because like, you know, like Alder Horton said, I hate to see people invest all this money, do all these things, and then come before us and go, hey man, you were arrested for a felony, you can't have a license. You know, and they're like, what? You know, I didn't know. And like you said, if it's already in the document, that's great, but they have to be, I don't know, we have to make it more easier, less difficult to get them to recognize, or maybe obvious. We have to make it more obvious. Maybe that, you know, in boldness, this is what you need to do. And if you don't even bother, because you're not going to go anywhere. You know, you're wasting our time and you're wasting everybody else's time. And I think that that's become an issue so far in on all of these licenses that we've been looking at lately. People are just not meeting the natural standard. So there's obviously a problem in the line of communication somewhere. And maybe it's just everyone who's applying, but it just seems to be a large number of them that are doing this. And so I think we need to do something different to minimize that if possible.
Sure, Alder Perez, let me be frank. I think some of the problem may come in terms of the application of these guidelines. The applications are pretty straightforward. They state what they state. They state that specific offenses, very specific offenses, disqualifies the person. The problem comes in when the committee members do not consistently apply these guidelines, because as an applicant, you read these guidelines and they say you're disqualified, but the guy before them comes in and he has all these convictions and he got his license, so why would it apply to me, right? So when you don't consistently apply these guidelines that you do create, that creates the problem, and it's confusing for applicants.
Yeah, I see that too, and I guess that we're not as consistent as we should be, and I noticed that from I didn't catch all the training, but the part that I did catch, consistency I saw was the big issue. Now, is there any way, and I apologize if I missed it, but does the fact that they come before the committee permit the committee to make an exception to those rules? Because that's what we've been doing in the past. And I've always not sure, I mean, isn't that what a conditional use permit is? Doesn't that make an exception to the rule to get something going? And isn't that in effect what we're doing?
No, the conditional use permit is something completely different. Are you talking about making exceptions to grant a license even though they are disqualified per the guidelines?
Yeah, I guess, because I'm just making a comparison to what we do with conditional use permits. You know, conditional use permits are because there's an exception or something different than the rule, right? And isn't that what we're doing in effect when they come before the committee and they say, hey, I want a license, we go, okay, you can have it, or no, you can't have it. And then we decide whether, because they've had too many incidents or not enough incidents, or whether they're somebody or not somebody, and we decide to make that exception. Can we legally make that exception? Isn't that why they come before the committee?
Well, the guidelines do allow for exceptions even when the person is disqualified. So if you read the last part of the guidelines, it talks about evidence of rehabilitation. Wisconsin statute was changed within the last few years to require the committee to examine whether the person has been rehabilitated, even though they do have a disqualifying conviction or arrest record, and still grant them a license so long as they have provided evidence of rehabilitation. The problem is, and the committee used to do this in the past, they would uniformly require the person to provide evidence of rehabilitation. For example, a documentation from DLC, the Department of Corrections, stating that the person has completed probation or parole, have been successful, letters of recommendation from the employer, letters of recommendation from other sources. So in the past, the committee has required some sort of evidence of rehabilitation, and every person who provides that is then approved. And that's fine, so long as you do that uniformly. The policy guidelines allowed for that. But at some point, the committee stopped doing that. It just said, oh, you said that you're rehabilitated, you're fine. You said that you're rehabilitated, we don't believe you, so you're not fine. So the problem is we're not doing it consistently again, and you're not requiring any documentation anymore at this point, but you used to, which is what you should go back to doing. That's what my recommendation would be.
So consistency would show when we go back and say you have to show proof. That would be consistency?
Right. So the statutes were changed to basically make it more difficult for the committee to deny based on an arrest or conviction record. So long as the person has evidence of rehabilitation, they can be granted a license. So you just want to make sure that you are requiring that part of it.
Is that something that's included in the paperwork?
It is included in policy guidelines, yes.
Not our paperwork. I mean, the paperwork that goes to the person who's applying.
Yes, those policy guidelines, you have them, and then the applicant also receives a copy when they pick up the application packet.
So what do you perceive to be the glitch? Why do we keep getting all these people that apparently went through all the process that didn't understand it? Do we have an informed voice here?
I think the problem is inconsistency, to be frank. I mean, I know I keep hitting the same nail on the head, but when you have policy guidelines and you give them to the applicant and you say, here are our rules, but then you keep bending your rules and you keep breaking them and you don't follow them, no one believes those rules. It's confusing to the person. So if you do want to start making bigger exceptions and allow everyone to get a license, that's fine. Have me change the policy guideline so that you're at least following the guidelines that you set up. I just don't recommend setting up policy guidelines and then doing whatever you want.
Thank you.
Alder Peterson, go ahead.
Yes. I think we have been pretty consistently lenient. Once again, I go back to the differences in licenses, although legally you can't, I guess. The big hangup seems to be omission, where somebody comes before us, and we've done that. We've asked people to get a letter from their parole agent or a letter from somebody to come back, and those are people that have stated that they're not eligible due to a disqualifying event in their life. The big problem we seem to have is where people fail to put something on an application. So it's not like you can ask, well, can you get something from your parole agent and say, so how would you suggest we best deal with lack of either knowingly or unknowingly, or forgetfulness or willingness? How should we deal with people that do not put everything on their application, that they have all the troubles they've had?
Sure. So by ordinance, an omission is a false statement, and the ordinance and the policy guidelines both state that a false statement results in the denial of an application. And that decision was made by the committee and by the council. You made that decision that said, look, if you're going to lie, we're just going to outright deny you. Everything else we can get over, right? Everything else we can work on rehabilitation. But if you don't tell the truth, we're going to deny. And that has been in the policy guidelines, and it has been in the ordinance since 2018. So if you want to change it, I mean, currently it states there should be good cause for the false statement, for you to get over that, to make an exception. But it also states that good cause is not stating, I forgot about it. And that's what you always get. So absent the person having really, really good reason, a legitimate good reason, a legal reason for failing to include that false statement, the ordinance and policy guidelines require you to deny at this point. And that's
Thank
what
you
I
very
would
much.
recommend that you do.
Thank you.
I'm gonna ask, I see, I don't know if Rob Ortiz has anything he wants to add to this at all. I see he's in on the conversation, just asking.
Nope, nothing from me.
Okay, much appreciated. So if there's no other questions on that motion to have this training after the committee is set. So I make a motion to approve. It was seconded. All those in favor say aye.
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 Opposed? All right, any other questions before we say goodbye? Okay.
I do
Alderman
have
Brilliant?
just, yeah, thank you. So I often refer to this binder that you gave us or gave me. And I was just wondering, you referenced at the way beginning that there has been some changes. I think you meant since 2018. I don't know if there's been any recent ones since I've received this. And also, no, okay. And then also, I think what might be helpful, and I was looking in when I believe Alder Perez was talking about that language written on the application or given to the applicant. I remember reading that over and over, but it's because I think I read their application when it comes before our committee and it states right on there why they would get denied. It's on every application. Can we get the forms that the applicant gets and be able to include that into our binder? So I was trying to find it in here. I thought maybe it might be in here, but if we could maybe get that so we can, a blank form, of course. So.
Alder Capania, I apologize. I know you asked for that a while back, and I did ask the city clerk's office. But the problem is because there are so many different types of license that the committee deals with, and there's so many different forms depending on the situation or the type of variation of license. It was almost impossible to print it all out and then include it as part of the application. However, if you just wanted forms that have to do with the alcohol licensing, I'm sure Amber can get you a copy of those.
Great. I think I mean, we have all these tabs in here, right? I mean, minus my little notes, but whatever would go in here. So we kind of know what we're looking at, right? Because there's certain, like their application form we see. I mean, I see every time I go through the packet, I see that, but if there's anything else they may see, it might be just good to have it in here. What we could possibly do, just because you're saying there's a vast amount, maybe if something does come up and I've noticed that there's not a form, I'll maybe reference that, maybe if we could get that and just do it as we go along. So.
Okay, sounds great. Thank you.
So being that there's no other business, we stand adjourned. And thank you very much, Nu. I appreciate it.
No problem. Thank you.
All right.
Thank
Bye.
you. Bye-bye.
Good night, everyone.